Are you buying commercial real estate in Texas? One wrong clause could cost you hundreds of thousands of dollars, kill the deal entirely, or just create massive headaches, all of which can be prevented by using a real estate attorney for your deal when working on the contract. I'm going to go over 5 legal landmines that you want to avoid in your next contract. So, one is the title and the survey objections. These are oftentimes overlooked, especially when the deal's being pushed by a realtor. I represent a lot of them, and I don't know if I've met one that when they get a title objection letter, they don't freak out and they're like, what do I even do? And they think they need to respond. Look, very common in commercial deals. The parties each have an attorney. The buyer, when they review the title commitments, there's going to be these things with title. And the buyer needs to preserve their objections. They need to say, I'm not going to close unless these things are removed from the title commitment, and then work with the title company to get them removed. Or if they can't be removed, then the buyer doesn't have to close on the deal. There's deadlines here, and these deadlines are often blown or they're not negotiated properly in the beginning. Maybe, for instance, there's just a really short deadline to review the title commitment, make any objections, ask for more time in the contract up front so your attorney can have time to work on these with you, to review the documents. This is even ever so more important when the property is a complicated commercial property. Look, if you don't do this part right, you could get stuck with a property that has title defects. You won't be able to get out of the contract. So these are things that you want to preserve and you want to work with an attorney to preserve. Now let's go into the second legal landmine, and that is zoning and use restrictions. Here in Houston, where I'm located, there's no zoning. Actually, super cool concept. Does that mean that property isn't regulated somehow? No. There's building requirements. There's oftentimes restrictive covenants. When I use that term, I refer to like a contract. It's a document by contract when the community is created that everyone in that community agrees to abide by certain things. We oftentimes see in these deals that even though the restrictions say no commercial property, someone puts up a commercial building, and then a neighboring building is sold or listed to be sold, and the client comes to us or we're working with the buyer and they're like, how can this be sold as commercial and there's a commercial building right next to it, but you're telling me, and the title company title commitment says that there can only be homes there. How can that be? I'll tell you, there is a violation of the restrictive covenants. Now, you can make legal arguments that because one violation's allowed, then the restrictions are waived, and then you can move forward with your commercial purpose. Clients typically want guarantees on this, and you're just not going to get a guarantee until you get a judicial determination, which can take years. So you're not going to do that either. You have to decide, am I going to walk this property? Better yet, what you could do is you could have maybe take some of that risk, but have the seller indemnify you, that if any action comes up in the future, that they'll pay for your defense, they'll pay for any judgment, things like that. That sweetens the pot, but any indemnification is only as good as the person that's giving the indemnification. So that's another thing to think about. And then I talked a lot about restrictions because Houston doesn't have zoning, but there are other places, every other place really in Texas, that have zoning. So you want to check to make sure that what you want to do with the property can be done by the property. And I'm just going to throw in one more thing, and that's flood zones. Texas has flooding, and there's all these other additional requirements depending on where you're at. You want to understand these and work with your attorney to understand these things. The third legal landmine is environmental. This freaks out pretty much everyone because the problem with environmental is if there's an environmental issue, everyone in the chain of title can be liable. You don't have to be the one that threw the nuclear waste on the property. You just have to have bought the property, or the next person to buy, or the next person. It doesn't even matter if you're anywhere in the chain of title on an environmental issue, you can get tagged, and it can be really nasty and it can be really expensive. So you want to do your due diligence on the property, do any environmental site assessments, and you want to make sure that your indemnifications are really beefy to cover you for any environmental issues. The fourth legal landmine is earnest money. So the earnest money can be refundable, it can be non-refundable. I think default is that it's refundable as long as the deal doesn't close for no fault of the buyer, but there's all kinds of different variations of this. So that brings up the contingencies. The most common one's the financing contingency. That says that if the buyer can't obtain financing, then they can walk the deal, they don't have to close, and their earnest money gets refunded to them. A lot of that can be spelled out. What kind of financing? So you put in the rate, the different kind of financing that they should or shouldn't be able to get, what is ever customary and reasonable, or else they can just walk out. And there's all kinds of other contingencies, especially on these commercial deals, that you can put in. And the fifth and final legal landmine that I'm going to cover today is assignment limitations. Why do I mention this? Creative financing's the buzzword. You don't see it as much, or I don't, at least in commercial deals as far as wholesaling and things like that. It does happen though. See a lot in more like residential type properties, single family homes, but everyone needs to be aware of it, because if you're going to lock up a property with the contract and there's no ability to assign it to someone else, and you do plan on wholesaling it or whatnot, you need to make sure that you're able to do that. And let me mention one thing that I do for myself personally is I'll enter into the contract in my personal name, and then I'll just assign the contract to an entity of mine. And I'll do this if I don't have time yet, if the entity is not set up. I can set up entity pretty quickly because I use series LLCs in order as my real estate investment vehicle, where I could set up separate series and I can do it really fast. And again, that's a whole nother video that I cover, is what a series LLC is and how a real estate investor can do it. But regardless, I'm going to go back to these assignments. If you think you're going to do it, put it in the contract up front. Don't wait and ask for forgiveness later. I've gone over 5 legal landmines, 5 things that I see in commercial real estate deals. And before you sign any commercial real estate contract, you should make sure that these issues are reviewed or addressed by a real estate attorney. If you want help on your next commercial real estate deal, let's talk.